You're going to start last class, and we have an intensive program also for today. So share my screen. So first of all, we're talking about the collective security system of the United Nations. Now, just 2 words to say, because we're not talking about not going to talk about the composition and way of functioning of the Security Council, but anyway, you know how it is composed. It is 5 permanent members and 10 non-permanent members elected for 2 years each. And clearly, a collective security system is based on the cooperation of the great powers. And so the veto power is certainly, if you wish, on one side, it is a big flaw of the system, because obviously the collective security system will never work when the interests of the 5 big powers are concerned. So whenever they are protagonists of a dispute, or whenever their strict allies are protagonists of a dispute or a conflict. But this was the price to pay, because the big powers, and this is for any collective security system, the big powers will never be ready to engage themselves in the maintenance of order and security if they don't get an advantage from this. So this was a high price, but it was the price to pay. And that is why we have a security system which works in a very bad way, but I mean, at least it works a bit more, certainly much more than the previous attempts, such as the one in the League of Nations. Now, what are the measures that the Security Council may adopt after having verified, after having identified a situation of threat to the peace, breach of the peace, or act of aggression? The Council may adopt provisional measures, which are only measures to prevent an aggravation of the situation, and they are the object of a recommendation of the Council. They are not binding. The typical provisional measure is ceasefire. The conflict started, 2 parties started fighting each other. The Security Council will will order the ceasefire, but however, this order, as mentioned, is not binding. However, if the order is not respected, the Security Council will take into account all the consequences of this, and will be able to adopt stricter measures. So it is true, it is not binding, but if the parties do not respect it, they may pay the consequences. The most important measures are under Article 41 and 42. 41 are the measures not involving the use of armed force. 42 are the measures involving the use of armed force. Colloquially and usually in practice, the measures not involving the use of armed force are called sanctions. The sanctions of the Security Council. they are the object, according to Article 41, they are the object of a decision of the Security Council. So they should be binding, and normally they are binding. Although sometimes the Security Council has decided to indicate as mere recommendations sanctions to member states. Sanctions are typically measures that need to be applied by member states against one state which is considered to be threatening the peace or having breached the peace or having committed an act of aggression. But nowadays, the Council also decides sanctions, establishes sanctions against individuals or companies. For example, individuals participating in international terrorism or financing international terrorism, or so it will be often state leaders, but not necessarily, also private individuals. It is always states who have to apply these measures. Companies, also companies who finance international terrorism, which is considered as a threat to international peace and security. So this is an example of the targeted sanctions, so-called targeted sanctions, or smart sanctions addressed against individuals and no more against states. In the list under Article 41, as you may see, there is a list of measures against a state. It is not a complete list, it is an open list. It is just a list of examples of measures that may be adopted. The Council has modified its action from these economic sanctions, especially the embargo, which is the total interruption of, well, not necessarily, I mean, it can be an embargo on specific goods, the interruption of the trade on specific goods, or it can be a total embargo when all economic connections with the state, all trade connections with the state are interrupted. It may be other measures as diplomatic relations. The whole of these measures, if the Council indicates to apply the whole of these measures, this is a total isolation of a country, as it did with Southern Rhodesia after the proclamation of Southern Rhodesia, of the independence of Southern Rhodesia in 1965. The practice saw the fact that the application of sanctions against states, especially if heavy sanctions, had heavy consequences on the population and not only on the state as a subject of international law. And that is why in recent years, this is one of the reasons why in recent years, the Council started to apply targeted sanctions against individuals and companies. So the idea is to hit the leaders, those who are responsible for a threat to the peace, and not the population. This, however, poses further problems in relation to human rights protection, but we cannot go into this issue now. If you have any question, of course, you just interrupt me. Article 25 of the Charter tells us that the measures, the decisions of the Security Council are binding upon member states. And Article 103 of the Charter is very important because it tells us that the Charter rules, the obligations under the Charter that arise under the Charter, which includes the obligations that arise under Security Council decisions, prevail over any other international agreement. So the Council, with its decisions, with its sanctions, is able to impose on states, on member states, measures which will derogate from obligations they have under international agreements. The Article 42 deals with the other category of measures, the armed measures. They are not necessarily to be adopted after the sanctions, because Article 42 says the Council, should the Council consider that measures provided in Article 41 have proved to be inadequate or would be inadequate. So at any moment, the Council can decide that it is necessary to adopt armed measures. Now, what Article 42 envisaged is that the Council would directly take an armed action with air, sea, or land forces, as a policeman would do, as a police agency would do. However, we are talking of the use of force at the international level, at the world level, so it is not simple police force, but it can be war. It can be proper war. An action to maintain or restore international peace and security. Such action includes demonstrations, blockade, and other operations by air, sea, or land forces of members of the United Nations, because obviously the United Nations has no army, has no sea forces or land forces, so the forces had to be provided by the members of the United Nations. But they had to be provided by the members of the United Nations on the basis of agreements concluded under Article 43. With the Security Council. So member states should have concluded agreements with the Security Council to put some of their military forces at the disposal of the Security Council to be used by the Security Council whenever the Security Council considered that necessary. It is also Article 48 that specifies that the action required to carry out the decisions of the Security Council shall be taken by all the members of the United Nations or by some of them, as the Security Council may determine. This may also apply to sanctions, but normally the decisions relating to sanctions are addressed to all member states. Normally, it's all member states which shall apply the sanctions decided under Article 41. So Article 48, it's more suited to armed measures because it is obvious that the Council would have used only the military forces of some states for a military operation, and not necessarily of all states. However, the model which is included in the Charter in Article 42 and following has never been implemented, because the agreements between the states members and the Council for putting at the disposal of the Council the state military forces have never been concluded due to the Cold War. But even after the end of the Cold War, they have never been concluded. That is why the Security Council has developed a different practice. On one side, the Security Council has developed sort of small military operations, which are the peacekeeping operations. These are not mentioned in the Charter of the United Nations. They are an invention of the United Nations. Peacekeeping traditionally consisted in the interposal of a small military force between two parties, especially to maintain a ceasefire, to control a ceasefire in a situation of armed conflict. However, some recent operations have included more coercive tasks. Peacekeeping operations are established, first of all, with military forces provided by member states, but not on the basis of the agreements under Article 43, which do not exist, but on the basis of specific agreements. So for each operation, a specific agreement is concluded with the states, member states willing to participate. No obligation. In recent years, these peacekeeping operations have been given broader mandates, including sometimes peace enforcement actions, which means coercive military actions to impose the peace in a certain area. Or peace-building functions. Peace-building means, at the end of an armed conflict, an action to reconstruct the institutions of the state. And to re-establish the conditions for a stable peace in the country. There are currently about 15 peacekeeping operations in several countries, especially in African countries or in other areas. Matilde, are you asking a question or what? Sorry, I don't understand you. I cannot hear you well.
It makes you have as any other citizen, the right to choose if we want to get vaccinated or not. Police officers and
No. Sorry, I cannot hear you, Matilde.
She said they have to take a test or the vaccine, and those who do not have the green card are considered unjustified persons. So they
Matilde.
Before and they are not. They might have their
in one country, no measures were adopted in respect of listeners.
Okay. No, not okay. Okay. So let us come back to peace building. Peace building is an action to re-establish. I was saying the council, the operations are currently in various African countries or in other areas affected by civil wars, especially. Peacekeeping operations are small military and not only military, partly military and partly civilian operations directly controlled by the United Nations, by the Security Council, through the intermediate action of the Secretary General. It is the Secretary General who effectively controls peacekeeping operations in name of and for the benefit of, I mean, under the direction of the Council of the Security Council. But the other way, which is more relevant to what we are dealing with now, is the authorization of states to use force. As the Council cannot directly use force, as member states have not put at its disposal military forces, then the Council authorizes, when it considers that a military action is necessary, the Council authorizes member states to use. That is why, and this also authorization of states to use force, which is not properly included in the Charter, has been, however, legitimized by customary international law. That is why we say today that the use of force is prohibited in international relations with two exceptions. One is at the unilateral level, self-defense. The second is the use of force authorized by the Security Council of the United Nations. These authorizations are addressed from time to time to states individually on the basis of Chapter 7, to states also acting in the framework of regional organizations or to regional organizations, because in fact, Chapter 8 of the Charter provides for a possible authorization to use force to regional organizations, such as the African Union or such as the Organization of American States, but also recently, in recent decades, also NATO has been considered as a regional organization. Even the European Union could qualify as a regional organization because it also carries out small military operations. So this is the way in which the Security Council acts in very short terms. Any question? The main cases that you have in practice where the first recommendation, it was not only an authorization, but a recommendation to use force, was in fact taken by the Council, adopted by the Council in 1950 with the war in Korea, as North Korea had attacked South Korea, the Council recommended member states to help South Korea to defend itself from North Korea, and therefore there was the war under the command of the United States against North Korea, which was, as you know, terminated without victory. I mean, it was just that the two parties remained as they were before. The country remained divided. The aggression, certainly to the south, was repelled, but the division of the country remained. And the second most famous authorization was given to help Kuwait to defend itself from the Iraqi annexation, occupation and annexation, and this happened in 1991. In this case, the Council authorized member states willing to cooperate with the government or already cooperating with the government of Kuwait to intervene if Iraq did not withdraw its forces from Kuwait. And the third most important authorization was given against Libya in 2011, when the Council authorized NATO, in fact, to intervene to protect the Libyan civilian population from attack in Libya. Any question? Okay. Now, let us go to the last topic, which is, however, a very big topic in international law, which is the peaceful or pacific settlement of disputes. So the question is, State A and State B, in the simplest situation, have a dispute among themselves. Because, for example, State A claims sovereignty over a part of a territory which is controlled by State B. This is a territorial dispute, but there are many kinds of disputes. There is a dispute when a state claims to have a right and the other state claims it doesn't have that right, and therefore there is an opposition of interest and of views between states. Now states can they can settle their dispute by using force, but this is obviously prohibited. So they have to settle their disputes peacefully according to, as we have already seen, Article 2, paragraph 3 of the Charter of the United Nations. Article 33 of the Charter goes a step further and provides that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security. This clause is only due to the fact that the United Nations are obviously not interested in very small disputes whose continuance is not able to endanger the international peace and security. So the parties to any dispute shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, resort to regional organizations or arrangements, or other peaceful means of their own choice. This is just an indication, and if they don't manage to settle their dispute, they shall go before the United Nations. This is just an open list of possible methods to settle peacefully a dispute between states. Because practice knows an infinite variety of methods to settle disputes. States are totally free to invent a new peaceful method to settle a dispute between themselves. So this is just a list of the methods which are mostly used in practice, in state practice. Now, in this list, you find two broadly different categories of measures, of methods. But first of all, how can a dispute between states be settled? And please take into account, states are not bound to settle their disputes. They are bound to settle their disputes peacefully. The important aspect that the Charter is pursuing is that states do not use force. That if they settle their disputes, they settle their disputes peacefully, by peaceful means. This is what is of interest to the United Nations, to the international community. There are disputes that have never been settled, but until no forcible means are used, there are no problems. So but if a dispute is settled, how is it settled? Well, there are basically two ways. Agreement between the states concerned, or the judgment or award of a court or tribunal. Because both methods are binding, so they settle the dispute. However, both these means of settlement are based on consent, so they are based on agreement. Because also a tribunal will be able to settle a dispute with a binding judgment or award only on the basis of an agreement between the parties concerned. Because the jurisdiction of international tribunals is always based on consent. This is the question number one that you shall keep in your mind. Jurisdiction, international jurisdiction, shall always be based, is always based on consent. But going to the specific methods to settle a dispute between states, we can distinguish the diplomatic methods negotiation, inquiry, mediation, conciliation. All these are diplomatic methods. And the arbitral or judicial method. The diplomatic methods are procedures whose aim is to facilitate the reaching of an agreement between the states concerned. To facilitate, because there is no guarantee that the agreement will be reached. While the arbitral and judicial method lead to a final binding decision, which is called normally judgment for the permanent tribunals, and sometimes it is called award for the arbitral tribunals. Is it okay up till now? Any question? Okay, within diplomatic methods, you may distinguish methods with the sole participation of the parties. There is only one method, which is negotiation. All the other methods see the intervention of a third party. Negotiation is the mostly used, probably, I would say certainly, diplomatic method for settling the dispute. The two states in question meet and discuss in order to reach a compromise, a solution, which is not necessarily based on international law, obviously. It can be based on legal considerations, but it can be based on political and other considerations, because it will be a compromise between the different positions of the two parties. But sometimes often negotiations lead to nowhere, or they are not even possible because the two parties don't speak to each other. So in this case, the parties will use a third party to facilitate their negotiations. So we find in the practice of state, we find the good offices. These are not mentioned in Article 33 of the Charter, but good offices are, in this case, a state, a third state, or normally the leader of a third state, or an authoritative international figure like the Secretary General of the United Nations, will lend its good offices in a case in which the two parties don't speak to each other. So they are in such a bad conflict with each other that they are not able to speak to each other. Therefore, in this case, the third party will intervene just to establish a contact between the two parties. So, for example, the Secretary General will refer to State B the ideas of State A and refer to State A the ideas of State B, in order to allow the establishment of communication. A further step is mediation. In this case, we also have normally an authoritative figure or a state, a third state. However, the intervention of the mediator is stronger than in the good offices, because the mediator will also investigate into the situation, will try to understand the situation and propose solutions to the parties. It is merely a proposal. The parties are not bound to accept the proposals of the mediator. All this will normally take place in a confidential manner. For example, this is a case of mediation. There was a dispute, territorial dispute between Argentina and Chile in the southern tip of Southern America, in the Tierra del Fuego, the Beagle Channel. They concluded an agreement to settle this dispute by arbitration. But the arbitral judgment was issued in 1977, and Argentina contested it. Argentina didn't like what had been decided. It was binding, but Argentina did not accept it. Therefore, there was a new dispute. The dispute continued. There was a new dispute between the two parties. And then both parties came to accept the mediation of the Holy See, which was lent with the direct participation of a single representative of the Holy See, who was Cardinal Samoret. And with the mediation of the Holy See, the two parties reached an agreement. And so they decided finally what was the frontier between them in the Beagle Channel. If you have any question, please ask. A third diplomatic method is inquiry. Inquiry is a situation in which normally a commission of experts is nominated by the two parties. The inquiry takes place when the two parties, not only they do not agree on how to settle a dispute, but they do not agree on the facts of the case. Take into example, for example, the dispute that there was between Italy and India on the accident that took place in the waters close to Indian territory, when the two marine officers, Italian Navy officers, were accused of having shot some Indian fishermen. The two parties disagreed on the facts, on what had taken place and where, first of all. Then they also disagreed on the points of law. So in case of disagreement on the facts, two parties may nominate a commission of experts, which will make an inquiry, also known as fact-finding, to verify the facts. What has happened? What has exactly happened? What is exactly the situation on the ground? Normally, the issue of the inquiry will not be binding for the parties. So the Commission of Inquiry will issue a report which will not be binding for the parties, unless the parties agree that it will be binding on them. They may, of course, agree that it will be binding on them, but it concerns only the facts, not the way to settle the dispute. A conciliation is similar to inquiry because conciliation normally takes place by means of a commission of experts nominated by the two parties. This commission operates similarly to a tribunal. So it will hear the two parties, it will analyze the case, and it will issue a final report, which, however, does not concern only the facts like an inquiry, but it proposes a solution, a settlement of the dispute. It proposes a settlement of the dispute, but in a more structured way with respect to mediation. So the difference between mediation and conciliation is that conciliation is more structured than mediation. Sometimes the report published by a conciliation commission is public, which of course will make, because it is never binding, but of course it will be a big pressure on the states parties to the dispute if the final report of the conciliation commission is binding. Is public, not is binding. It is not binding because otherwise it would be a tribunal. So all these methods, as I mentioned before, are meant to facilitate the reaching of an agreement between the two parties, but it is not guaranteed that the agreement will be reached. Now, the Security Council has a role, the United Nations play a role in all this, because the Security Council under Chapter 6, the most important chapter, as we have seen, is Chapter 7, related to the action in case of threat to the peace, breach of the peace or act of aggression, but Chapter 6 comes before in all senses, because Chapter 6 comes before the situation reaches the threshold of a threat to the peace. The Security Council may play a relevant role in helping the parties to reach a settlement of their disputes. But under Chapter 6, Security Council can take no decisions, no binding decision, only recommendations to the parties.
Excuse me?
Yes.
I think there are some questions in the chat.
Okay. Sorry. So it is better if you take the floor directly, because sometimes I see the chat only at the end. Anyway, what's the difference between means of settlement and settlement methods? Well, it is just a way to understand each other. I mean, it is not other persons, other experts may use different terms. What I mean is there are two ways to settle a dispute. One way is the agreement, the other way is the judgment. Then there are a series of methods that can facilitate the reaching of an agreement or can lead to the settlement of the dispute. Okay? And then, second question, how do the states choose the mediator? they just have to reach an agreement on who is the mediator. There will be one state proposing a certain, or sometimes the mediator will propose himself or herself. For example, the Secretary General will offer his good offices or his mediation. And so it is for the parties to accept it or not. Do the third states apply to the role in an informal way, or is there a formal procedure? No, no formal procedure. There is no procedure at all. You don't apply to be a mediator. So I'm sorry if you wanted to be a mediator in the future. In this kind of disputes, there is no application procedure. It is the states that will have to choose you. Could you? Sorry?
I have a question as well.
Okay, please, Julen.
Can you repeat what a good office is?
What?
The explanation for a good office in diplomatic methods. A good office.
Good office. Is that what your question? Good
yes,
office.
Yes.
Okay, the good office is, it's just a third party which helps to establish a contact between the two parties in dispute. Because the two parties in dispute don't speak to each other anymore. So it is just an intervention to help establish a contact between the two parties. Okay?
Okay, thanks.
You're welcome. Then there is another question. Could you repeat the difference between chapter 7 and chapter 6? Yes, I will repeat it. So, in chapter 7, the United Nations Security Council is able to take coercive actions, as we have seen, either adopting binding sanctions or deciding military measures, please, or deciding military measures. And this, when the Council has verified that there is a threat to the peace, a breach of the peace, or an act of aggression. But before the situation reaches such a threshold of gravity, the Security Council may intervene under Chapter 6 just to help the parties to reach a solution to their dispute. And to help them by means of recommendations, not by means of binding decisions. Is that clear? Okay, I don't see any objections, so I guess that okay, perfect. So what are the powers of the Security Council? Specifically, it can investigate. So inquiry can be done by the Security Council. Before we were talking of an inquiry under the initiative of states in dispute. But even the Security Council can decide to investigate into any dispute to understand the facts, how the facts are, and to be able to take further actions on the situation. The inquiry, in fact, is useful for the Council also to decide whether the situation falls under Chapter 6 or under Chapter 7. So what is the gravity of the situation? Then the Council, first of all, the members, but also the non-member states of the United Nations may bring any dispute between them to the attention of the Security Council or the General Assembly, because we will see there is also a role of the General Assembly. And the Security Council may, on one side, at any stage of a dispute between states, recommend appropriate procedures or methods of adjustment, which means it may recommend, for example, it can recommend to the states parties to dispute, you should go to arbitration, or you should try a mediation. But in fact, what the Security Council also does is to directly establish such diplomatic methods. For example, the Security Council may appoint a Secretary General of the United Nations as a mediator in that dispute. The other possibility for the Security Council is to use the language of Article 37 of the Charter, to recommend to the parties to dispute such terms of settlement as it may consider appropriate, which means to recommend to the parties a solution of the dispute, how to settle their dispute, the merits of their dispute. Let us take a famous example. Security Council Resolution 242 of November 1967. Which concerns the dispute in Palestine. It was taken after the occupation by Israel of the Palestinian territories after the 1967 war in the Middle East. The Council in this resolution affirmed that the fulfillment of Charter principles required the withdrawal of Israel armed forces from territories occupied in the recent conflict, and respect for and acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area, and their right to live in peace within secure and recognized boundaries, free from threats or acts of force. So the Council was indicating to the parties what the parties were not ready to concede at the time, because it was indicating to Israel the need to withdraw from occupied territories, and it was indicating to the Palestinian side the need to recognize the sovereignty, territorial integrity, and political independence of Israel, which the Palestinians were not ready to, at the time, to undertake. This was a recommendation. It was not a binding resolution. It was a recommendation under Chapter 6 of the UN Charter. But this resolution has been accepted by the parties later on as the basis for the settlement of the Middle East crisis. What is the problem? Is that each party intends the resolution in a different way, because Israel intends withdrawal from territories as not necessarily meaning withdrawal from all territories occupied in the recent conflict. But if we go and see the French version, for example, of the resolution, it speaks about a withdrawal des territoires occupés, which means from the territories occupied in the recent conflict, which means the whole territories occupied. in the recent conflict. In reality, the resolution would indicate the withdrawal from all the territories occupied in the 1967 conflict. Therefore, we may say that obviously the resolution until now has had no effect after various decades on the resolution, on the settlement of the Middle East crisis, unfortunately. But you will often hear about this resolution and make reference to this resolution as indicating a binding solution. But it is not binding because of the powers of the Security Council. If it is binding, it is because it has been formally accepted by the parties. Also, the General Assembly plays a role in the diplomatic settlement of international disputes, because under the UN Charter, Article 11, the General Assembly may discuss any questions relating to the maintenance of international peace and security, and may make recommendations to the parties concerned. So the parties, as mentioned before, can also bring their disputes to the attention of the General Assembly instead of bringing them to the attention of the Security Council. So also the General Assembly can consider disputes and make recommendations to the parties. The only limit to the action of the General Assembly is that under Article 12, while the Security Council is actively dealing with the dispute, the General Assembly shall not make recommendations. And this due to the primary responsibility of the Security Council in the maintenance of international peace and security. Which means the General Assembly also has a responsibility in the maintenance of international peace and security, but it is a secondary responsibility with respect to that of the Security Council of the United Nations. Any question on the role of the Security Council or the General Assembly? No question? Are you sure? Okay, now let us go to the last part of this topic, which is the arbitral and judicial proceedings. So the adjudication of international disputes. This is, as I mentioned before, this is a way of settlement, a method through which disputes are settled because there is a binding solution for the parties. Because the procedure necessarily leads to a binding solution. The procedure before a tribunal necessarily leads to a judgment. Well, it may of course lead to a judgment according to which the tribunal has no jurisdiction, but that is a different case. That means that that tribunal cannot decide on the dispute. Now, what are arbitral proceedings? You have arbitral proceedings also in domestic legal systems. An arbitral proceeding means that two parties, for example, two individuals, have a dispute between each other and they decide to nominate a third individual to decide their dispute. Or they decide to nominate three friends of three common friends, compose a commission to decide their dispute. So the first to be born in the international community were arbitral proceedings. Arbitral proceedings take place in this way. There is a dispute between State A and State B. State A and State B conclude a special agreement. It is often known under the French term of compromis. With this special agreement, the two parties, so the consent, remember, at the basis of jurisdiction, the consent. Through this special agreement, the two parties select either one arbitrator or a certain number of arbitrators. Normally, they will be 3 or 5. Which is, of course, due to the fact that they may decide by majority if they are in disagreement. And they confer on the arbitrator. Who is the arbitrator? How is he chosen? For example, it could be, again, it could be the leader of a third country. But it could be, and in the practice of states that became more and more, an expert in international law. So they select the arbitrator or the arbitrators, and they confer on the arbitrator or arbitrators the task of settling the dispute, binding themselves to accept the final award of that tribunal. This is arbitral proceedings, arbitral solution, arbitral tribunals. It is a tribunal nominated ad hoc by the parties to decide that specific case or a series of related cases. It could also be. Between the 19th and the 20th century, there was a first institutionalization of arbitral tribunals with the creation of the Permanent Court of Arbitration, PCA, which is still existing today. Some of the cases we have been considering were decided within PCA. Now, the PCA is not a court. Even if it is called the Permanent Court of Arbitration, it is not a court. The PCA is merely a list of arbitrators and a secretariat, an administrative office. It is done in the way that states may just go there and choose the arbitrators for their specific tribunal in that list. So it is a list to be used by states to choose the arbitrators that will compose a specific arbitral tribunal established to decide a dispute between those states. While the first universal permanent court, a permanent international court, was the Permanent Court of International Justice established after World War I. This was the first judicial court at universal level, which was linked to the League of Nations. This was a judicial court, so the difference between an arbitral tribunal and a judicial court or tribunal is only that the first is nominated ad hoc by the parties to settle a specific dispute. The second is a permanent court or permanent tribunal, which also means that, of course, the judges of a permanent court are not chosen by the parties to the case. But this is the only difference between an arbitral tribunal and a judicial court. Because in both situations, arbitral tribunal or judicial court, the proceedings are based on the consent of the parties. The jurisdiction of both kind of courts are based on the consent, is based on the consent of the parties. Is it clear? Is the difference between arbitral and judicial tribunals clear? Okay. Now we come to the most important international tribunal that you all know, which is the successor to the Permanent Court of International Justice, and it is the International Court of Justice, which was established by the Charter of the United Nations of 1945. The International Court of Justice is the most important international court, not only because it is universal in the sense that potentially all states can go before the International Court of Justice, but because it has, among international courts, it has the broadest competence, because it can decide any legal dispute between states on any subject matter. While other tribunals have a specific competence. For example, the UN Tribunal on the Law of the Sea has a competence only in relation to disputes relating to the law of the sea. And then we have, of course, the regional human rights courts. Then we have, of course, the International Criminal Court, which does not settle dispute between states, but decides on the criminal responsibility of individuals. So the International Court of Justice is the main tribunal permanent tribunal deciding disputes between states. It is also the principal judicial organ of the United Nations. It is one of the principal organs of the United Nations. However, this does not influence on its functioning because it works as a totally independent body. It is not subject to the direction or control of any other body of the United Nations. And it works, it functions on the basis of the statute, which is in fact the statute based on the statute of the Permanent Court of International Justice with some amendments. And the statute of the court is an integral part of the Charter of the United Nations. According to Article 94, each member of the United Nations undertakes to comply with the decision of the International Court of Justice in any case to which it is a party. But in fact, each state which goes before the court will have to accept the binding nature of the decision taken by the court. Article 94, paragraph 2, as you may see, also provides for a possibility of the Security Council to intervene, to adopt measures to give effect to a judgment of the International Court of Justice if one of the parties does not comply with such a judgment. But Article 94 was never applied. The Security Council never adopted measures to enforce judgments of the International Court of Justice. The court shall consist of 15 members, no two of whom may be nationals of the same state. There is, and the members shall also represent the various legal systems of the world. So you have, in fact, judges from all the parts of the world in the International Court of Justice. Yesterday, one of you asked me, how are international judges chosen? Well, here is how the judges of the International Court of Justice are chosen. They are elected by the General Assembly and by the Security Council, so there is a double vote in the General Assembly and the Security Council, from a list of persons nominated by the national groups in the Permanent Court of Arbitration. So basically, international judges are always nominated on the basis of candidates presented by states. It has been a practice of the court to usually have one judge for each of the permanent members of the Security Council of the United Nations. But it is not necessarily like that. Currently, the United Kingdom has no judge in the court. And of course, you have to remember that judges are chosen on the basis of their experience in international law, on the basis of their moral character. This is what the Charter says. The expectation is obviously that they act in total independence, so it is not because the judge is a judge of one has the nationality of one state, that he or she will necessarily decide in favor of that state. The members of the court are elected for 9 years and they may be re-elected. In fact, there are judges who lasted for a long time. But a typical aspect, which is a bit of an arbitral aspect of the International Court of Justice, is that there is the possibility to nominate judges ad hoc. Which happens in particular when one of the two parties has a judge of its nationality on the court, while the other party has not. In that case, the other party has the possibility of nominating a judge ad hoc. Of course, the judge ad hoc may have the nationality of the state or not. This brings an arbitral element into the functioning of a permanent court, because you can understand that in arbitral tribunals, the parties have much more influence on who are the judges, the arbitrators. And the court has also the power to establish its own rules of court, which are a detailed regulation of how the proceedings take place before the International Court of Justice. The court has basically two competencies. On one side, it can hear any legal dispute between states. On the other side, it can issue, as you already know, advisory opinions. Only states may be parties in cases before the court. So the court cannot hear a legal dispute between a state and an international organization, or between two international organizations. And it cannot hear the dispute between a state and an individual. Now, the very important point is, as we have said since the beginning, that jurisdiction is based on consent. How is consent expressed by states in relation to the International Court of Justice? So, the jurisdiction, the fundamental article is Article 36 of the Statute of the International Court of Justice, annexed to the UN Charter. The jurisdiction of the court comprises all cases which the parties refer to it and all matters specially provided for in the Charter of the United Nations, but there is no matter specially provided for in the Charter of the United Nations. So in other treaties and conventions in force, which means that the court may be addressed by means of a special agreement, as in for an arbitration. The two parties to a dispute conclude a special agreement and refer a case to the court, or on the basis of a clause contained in a treaty. We have been considering several clauses. You remember in relation to the Convention Against Genocide, the clause on the basis of which the states parties may refer any dispute relating to the interpretation or application of that convention to the International Court of Justice, which means that only one of the two parties may refer the dispute to the International Court of Justice. So in this case, the consent to the jurisdiction of the court is expressed in the convention in question. For example, the UN Conventions Against Genocide. But there is also a further way for the parties to express their consent to the jurisdiction of the International Court of Justice. I have your consent on the closing of the window. So there is a third way, which is the optional clause. The optional clause is a declaration that each state party to the statute, which means member of the United Nations, may at any time issue. Any state member of the UN may at any time declare that it recognizes as compulsory in relation to any other state accepting the same obligation the jurisdiction of the court in all legal disputes. But then there are a series of limits that normally states put to their declarations. So the optional clause is also, in fact, an agreement because it functions in a mutual way between two states having issued the same declaration. The court will have jurisdiction in a dispute between state A and state B if that dispute falls into the declarations issued by the two states. Is that clear? That also the optional clause is in fact a mechanism of international agreement, because in order to establish the jurisdiction of the court, you will have to unify the declarations of the two parties. The court will have jurisdiction only in as much as the declaration of state A coincides with the declaration of state B. For example, state A declares that it accepts the jurisdiction of the court in relation to all disputes starting from 1st January 2010. State B declares that it accepts the jurisdiction of the court on all disputes starting in 2015, which means that disputes after 2015 will be subjected to the jurisdiction of the court between states, disputes between state A and state B. Is it clear now? So, in fact, you can see that Article 36 is always based on consent. However, the more you have these declarations, the more you come to a situation in which is similar to that of domestic courts, because any state will be able to sue another state before the court. But in fact, it is not like that, because only more or less 70 states have issued such declarations. And there are states which have withdrawn their declaration of acceptance of the jurisdiction of the International Court of Justice. Disputes are decided on the basis, I still keep you a few minutes, disputes are decided on the basis of international law. You already know Article 38 of the Statute of the International Court of Justice. The parties could also agree for the court to decide the case ex aequo et bono on the basis of considerations of equity, but that does not happen. The court may issue, before deciding a case, it may issue provisional measures in cases of urgency. A typical case that has arisen in recent years is the case of a dispute over the execution of a person condemned to the death penalty. As there was a dispute on the legality of the execution, the court indicated to the state in question the need to suspend the execution until the final decision of the court. In this case, in those cases concerning the United States, there were 3 cases concerning the United States. The dispute was relating to the fact that the United States, the local state of the United States in question had not guaranteed the consular officials of the foreigner, in this case a German citizen, which had been convicted to the death penalty, to have access to this person, which they have the right under the Consular Relations Convention of 1963. And so the proceedings had not been lawful due to that. Now, the court indicated these measures to the United States in this case, and the court stated that provisional measures are binding. However, the United States did not comply, and they executed the persons in question. Apart from the proceedings relating to provisional measures, normally the trial goes through a written phase and an oral phase. And the trial is concluded, so there is an exchange of written memories between the 2 parties, and then there is the debate before the court. And the proceedings are concluded, of course, by the judgment. And Article 59 tells us that the judgment of the court is binding, but only between the parties to the case, which is something you already know, because we have seen that we have already mentioned the fact that there is no precedent in international law, in international courts. Although the courts tend to follow their previous jurisprudence, their previous case law, but there is no obligation to do so. So each case is binding only for the parties to the case. Each judgment is binding only for the parties to the case. However, we know that the judgment of the International Court of Justice is always authoritative, apart from the solution of the single case. And the other possibility for the court, and with this we will conclude, it's the advisory opinions. Advisory opinions are not binding. They may be requested by the General Assembly or the Security Council or by other organizations, specialized agencies of the United Nations, such as ICAO or the World Health Organization, if authorized by the General Assembly. But while the General Assembly may request an advisory opinion on any legal question, the other organizations may only request advisory opinions on legal questions arising within the scope of their activities. So only related to their specific competencies. The advisory opinions of the court are by definition advisory, therefore they are not binding. However, they tend to be authoritative in as much as the judgments of the court. So certainly the International Court of Justice, as you already know, because we have been mentioning it all over our course, has greatly contributed to the interpretation and identification and even to the development of international law. Any question on the International Court of Justice? Or any other question? It is your last occasion. Not really, I mean, you can of course contact me. But it is your last collective occasion to ask questions. Okay, if you have no questions, thank you very much for your attention during all these classes. And I hope I will see many of you on the 16th of December. Okay? Thank you.
Thank you. Thank you. Bye.
Thank you. Bye-bye.
Thank you.
Yeah, thank you. Bye-bye.
Bye-bye.